guys, this is Attorney Pramdi and welcome back to my channel. So for today's video, we will discuss kung yung divorce ba na na-obtained abroad is valid in the Philippine jurisdiction. Okay? So yung case natin ay may GR number na 221029. Bakit importante yung GR number? It is like the identification number ng case. So pag itinype nyo yon sa browser ninyo, lalabas yung detalye ng kaso. Alright? So this was decided in 2018. It is a landmark case. Why? Kasi the Supreme Court interpreted Article 26, second paragraph, according to the spirit of the law and not on the letter of the law. Okay? So, ayun. Umpisahan natin. This case was filed in Regional Trial Court of Dagupan City, Pangasinan. So, shout out at Sari taga Pangasinan. Proud Pangasinense here. Okay? So, papangalanan natin yung petitioner as the wife. Okay? So, si wife, ikinasal sa isang Japanese citizen. Alright. Ikinasal siya, so nagkaroon ng entry of the marriage sa civil registry ng San Juan, Metro Manila. And then, pagdating sa Japan, in December 2011, nagkaroon ng judgment ang Japanese court regarding the divorce decree filed by both. Okay, so nag-grant ang kanilang divorce in 2011. So by 2012, nag-file siya sa Philippine court ng recognition ng foreign decree. Okay? Ngayon, pagdating sa pagdating sa RTC, denied yung kanyang petition. Alright? So, why is it denied? Ang sabi ng Regional Trial Court, according to Article 15 ng New Civil Code of the Philippines, the Philippine national law shall govern the right of a person or of a person over family rights and duties, the legal capacity to enter into contracts and civil relations, including marriage. Okay, so Article 15, it is what we call nationality principle. Okay, so yung national law ang mag-govern sa lahat ng issues regarding family rights and legal capacity to enter into civil relations or marriage or contracts. Okay? Now, so since denied, umapila ngayon itong si wife sa Court of Appeals. Ngayon, si Court of Appeals naman, binaliktad niya itong si Regional Trial Court. Kasi ang sabi ni Regional Trial Court nga, based on our national law, Philippine law, does not recognize absolute divorce. So, denied yung kanyang petition for recognition of the foreign divorce. Now, pagdating kay Court of Appeals, binaliktad nila si RTC. Ang sabi naman ni Court of Appeals, Article 26 ng Family Code, second paragraph. Okay? Ito ang sabi. Where a marriage, kapag ka yung marriage is between a Filipino citizen and a foreigner, validly celebrated, tapos thereafter, may divorce na validly obtained abroad by the alien spouse, capacitating him or her to remarry, the Filipino spouse shall likewise have the capacity to remarry under Philippine law. Okay, ano ibig sabihin niyan? Kapag halimbawa, si foreigner nakakuha ng divorce laban sa kanyang asawa na Pinoy or Pinay. Tapos yung divorce na nakuha niya abroad, inaalaw siya na ikasal uli. Etong Filipino spouse will also have the right na ikasal uli under Philippine law. Yan ang sabi ng Article 26. Pero hindi yan automatic ha. Hindi yan automatic. Kailangan mong kumuha ng foreign decree and kailangan mong ipa-recognize ito. So magpa-file ka ng petition sa court for recognition of a foreign judgment. Okay? So ayun, ang sinasabi ng Court of Appeals, valid yung divorce na nakuha abroad, and under Article 26, second paragraph, dapat i-recognize ng Philippine jurisdiction. Okay? So, dapat i-grant yung petition ni wife for recognition of the foreign divorce. Yun ang sabi ni Court of Appeals. Ngayon, nag-motion for reconsideration si Solgen. Denied. So, umapila siya ngayon sa Supreme Court. Ngayon, ano ang sabi ng Supreme Court? Dito sa Philippine jurisdiction, okay, meron tayong 4 na rules. Philippine law does not provide for absolute divorce. So, dito sa ating bansa, walang absolute divorce. Absolute divorce, ito yung nagta-terminate ng marriage. Okay? And number 2, so yun yung una, we don't have absolute divorce here in the Philippines. Number 2, consistent sa Articles 15 and 17 of the new Civil Code, sabi, the marital bond between two Filipinos cannot be dissolved even by an absolute divorce obtained abroad. So pag dalawa kayong Pinoy, kasal kayo, tapos later on nakakuha kayo ng divorce abroad, hindi yon valid dito sa bansa natin. Okay? Yun yung number 2. Number 3, yung absolute divorce na nakuha ng mag-asawa na parehong hindi Filipino. Okay? They are foreigners. Both aliens. Okay? So, nakakuha sila ng absolute divorce, may be recognized in the Philippines, provided consistent with their respective national laws. Okay? So, kung dalawa kayong foreigners, nakakuha kayo ng absolute divorce abroad, pwede iyong iparecognize dito sa Philippines. Ipoprove nyo lang na yung divorce was secured according to your national law. Right? Doon sa law na ng bansa kung saan ka nanggaling or kung saan ka citizen. Okay, now number 4. Nagkakaroon tayo ng problema pagdating sa mixed marriage between a Filipino and a foreigner. Okay? Kasi kapag si foreigner nakakuha ng divorce abroad, pwede siyang ikasal uli. Pero si Filipino spouse, naiiwan siya na nakatali pa rin doon sa kanyang foreign spouse. So, ayun yung fourth situation, yun ang inaddress or sinolusyonan ng Article 26, second paragraph. Kaya, nagkaroon tayo ng amendment. Okay? So, nagkaroon ng amendment in 1988. Itong family code natin. So, nagkaroon tayo ng Article 26. So, yung paragraph 2 ng Article 26, ino-authorize under the principles of comity, the Philippine jurisdiction recognizes valid divorce obtained by a spouse of foreign nationality. Okay? Yun nga lang, yung pagdating sa child custody, yung child support, yung property relations, okay, ang magdedetermine pa rin nun is the Philippine court. Okay? Now, ang idea ng second paragraph, Article 26, is para maalis yung injustice. Kasi nga naman, kapag kasi foreigner nakakuha ng divorce, pwede siyang magpakasal sa iba. Pero yung asawa niya na Pilipino o Filipina, hindi po pwedeng mag-asawa kasi nakatali sa kanya dahil nga hindi natin nare-recognize yung divorce. Kaya tayo nagkaroon ng second paragraph ng Article 26 para maalis yung injustice or yung absurd situation na yung asawa mo na foreigner pwedeng mag-asawa pero ikaw nakatali ka sa kanya dahil hindi kinikilala yung divorce dito. Kaya tayo nagkaroon ng Article 26, second paragraph, para maiwasan yung ganong absurd situation or impossible situation or unfair or unjust situation. Okay? So, ayun ang sabi ng Supreme Court. Ngayon, balikan natin yung second paragraph. Diba, ang sabi ng second paragraph ng Article 26 is, where a marriage between a Filipino citizen and a foreigner is validly celebrated and a divorce is thereafter validly obtained abroad by the alien spouse, capacitating him or her to remarry. The Filipino spouse shall likewise have the capacity to remarry under Philippine law. Okay, so ang question dito basically is, according sa second paragraph kasi, yung divorce should be obtained by the alien spouse. In this case kasi, si wife ang nag-initiate ng divorce sa Japanese court against dun sa kanyang Japanese husband. So, nagkaroon ngayon ng conflict sa letter of the law. Alright? Ngayon, makikita natin dito na binigyang buhay or binigyan ng weight yung interpretation ng law on the intent or on the spirit and not on the letter. Okay? So, nung binalikan ngayon ng Supreme Court yung intention ng ating mga lawmakers noong ginagawa yung or nung nagde-debate sila regarding the this provision on Article 26. So, ang intention nila actually that time was to prevent this situation wherein the foreign spouse can remarry and the Filipino spouse is left with no other choice because divorce is not recognized in the Philippines. So, yun yung sinusolusyonan nila. Ngayon, ang sabi ng Supreme Court, kung sasabihin natin na in this case kasi, ang nakakuha ng divorce decree is not the alien spouse, but the Filipino spouse. Okay, so kung susundin natin yung Article 26, second paragraph, sabi ng, literally, ang sabi ng law, the divorce should be obtained by the alien spouse. Alright? So, ang sabi ng Supreme Court, if we are to follow the literal interpretation of the law, it will defeat, okay, the purpose or the spirit of the law. Bakit? Kasi ang intention mo is to prevent the impossible situation or the absurd situation or the unjust situation kung saan si foreigner po pwedeng mag-asawa ulit dahil sa divorce na nakuha niya abroad, pero itong asawa niya na Pinay or Pinoy is hindi po pwedeng makapag-asawa dahil nakatali pa siya. So, ayun yung intention ng mga lawmakers nung ginagawa nila itong batas na to. So, kung ia-apply mo literally yung interpretation ng Article 26, yung dapat yung divorce ay nakuha ng alien spouse at hindi Filipino spouse, ang sabi ng Supreme Court, nandun pa rin yung injustice, right? Kasi si Filipino spouse ay hindi pa rin po pwedeng ikasal. So, ang sabi ng Supreme Court, um, the spirit of the law should be upheld, or the intent of the law should be upheld, or should be ano bang term nun? The spirit of the law should be upheld over the literal interpretation of the law. Okay? So in this case, yung divorce na nakuha or na-secure ng Filipino spouse was held to be valid by the Supreme Court. Okay? So, sabi ng Supreme Court, inaffirm nila yung Court of Appeals decision by saying that the what the law is trying to prevent is the situation na, yun nga, si Filipino being married to his or her alien spouse, and the alien spouse is no longer married to the Filipino spouse. So, to give um, validity to the, or to, ano ba yun? To give the to give spirit to the law, the foreign divorce obtained by the Filipino spouse should be held valid in this jurisdiction. Okay? So, ayun. So, ang resulta nun is, pinabalik yung case na to sa kung saan siya nag-originate sa Regional Trial Court para umpisahan yung presentation ng evidence. Kasi, yung foreign decree or yung foreign divorce will still have to be proven sa lower court, okay? Philippine jurisdiction cannot take recognition doon sa foreign decree without proof doon sa validity ng I mean doon sa law na naging basis nung divorce. Okay? So, ayun. Please subscribe to my YouTube channel and like my Facebook page, Attorney Promdi, for more legal cases in the future. I hope you enjoyed watching, and thank you for your support.